It's always the most frustrating thing for mediators when you see people digging a hole and they just won't put down the shovel. The system is not perfect. The other side is not going to agree to all these facts. You're going to say this happened, and they're going to say that happened. And if the jury believes that happened instead of this happened, we're going to have a problem. People don't go to a lawyer because they have a legal problem. People go to a lawyer because they have a personal problem. Something in their life has created a problem for them or maybe an opportunity for them. Even if it's business, it's still personal. Businessman or woman that's fighting with their partner, this affects their income. This affects how they're going to take care of their family. This affects how they feel at night when they go to bed, their stress levels. It's all personal. What advice would you give to litigators and everything? And it's those two things. Set expectations and prepare.
What keeps you passionate about the work that you do?
I love helping people. I love what I do. When I wake up in the morning and I have a mediation, that's a good day.
All right, so we're going to jump right in. Welcome, everybody, back to Beyond the Briefcase. Today's episode is called The Art of Resolution, what mediation teaches us about people, conflict, and community. And this is the Collier County Bar Association's podcast, partnered with Beyond the Briefcase. Today's guest I'm joined by is Steve Blount with Blount Mediation. Blount Mediation is a respected neutral when it comes to helping attorneys resolve cases with clients and families and helping them find clarity, compromise, and closure across Southwest Florida. And Steve is the man. So welcome, Steve, to the show.
Glad to be here.
So you probably see more human behavior in one mediation than most of us see in a year. I don't know what the average mediation is, but does that sound accurate statement?
I think that's probably true. Doing almost 200 mediations a year, all of them at least a half day, if not a full day, actually probably most a full day. So, yeah, you see a lot of interesting behaviors.
Yeah, so now you're doing most of your mediations via Zoom.
95% of them via Zoom.
And COVID is to blame for that, right?
Well, to blame or thank.
Yeah.
Depending on how you look at it. I think Zoom has been a very good platform. I think it works very well, especially some large mediations, construction mediations that might have, 10 or 12 parties, each party having an attorney and then a coverage counsel and then a insurance adjuster, then a party rep. So you have 4 times 12. I mean, sometimes you do mediations with as many as 50 or 60 people in the room, and it's easy to manage on Zoom.
Yeah.
And if not, you have to rent, conference rooms at a hotel. Everybody has to travel someplace to some neutral site.
And then you're running around whether you're going to caucus or back and forth.
And there's a lot of wasted time as opposed to just one click and I'm in the other room.
So when I met you about 10 years ago, civil litigation was your primary practice, meaning about more than 50% of what you did. What originally drew you towards mediation as your primary practice?
Well, really the same thing that drew me to litigation. And you hear a lot of people say, I was tired of litigating and mediating is so much easier. Well, if you put a lot of effort in it, it may not be as easy as people think. But what I learned about myself over time is that the reason I liked to litigate, the reason I liked being an attorney was I like helping people. And people come to you when they're in a bad spot in their life or an opportunistic spot in their life and they need help to take advantage of the opportunity or to get out of the problem. And I like that. I like being the guy that comes in to help. It's very gratifying.
Yeah.
And I realized through the mediation process how many more people I could help mediating than litigating. Because litigating, you're a small firm. Maybe, I had 2-3 lawyers in my firm at various times. And so maybe we could help, 50, 60, 70 clients at a time at the most.
Mm-hmm.
Every day I get to help at least 2. And I do that a couple of 100 times a year by myself. I can help a lot more people.
Yeah.
And that's very gratifying.
Yeah. Well, was there a moment when you realized that mediation was your true zone of strength?
I think probably shortly after I started doing it, when I first decided to do it, I actually did a full-day mediation with Jim Dolman. And if he would let me, I would call him my mentor.
Okay.
And after the mediation was over, I asked Jim to stay, and we went over to the Bay House and had a drink together. And I said, I'm thinking about doing this. What do you think? And he was, oh, you're going to be so good at this. This is good. And I didn't believe him, but I said, okay.
Mm-hmm.
So I went to the training that he recommended. I did my ride-alongs primarily with him. I ended up having to do one, I think, with somebody else. And then I started doing these mediations, and first year, maybe I did a dozen. Then the next year it was 30. And then the next year it was 70. I mean, and it was doubling year over year. And what I was finding is every time I did a mediation with a new attorney, that attorney would call me back for another mediation. And so I thought, this is going pretty well. And I was settling a high percentage of cases, which is my goal.
It's a pretty good indicator of strength.
Yeah, I think so.
I've sat in a few mediations enough with different mediators to see the different strengths that they have, and some of them come off like more assertive than others. And I think that your background as a litigation attorney really helps you avoid becoming that mediator that just doesn't settle cases, because you've been working for years how to settle something, how to keep a case out of court, so you can transmute that to the mediation process, and that's probably one of the reasons why you're so effective.
Well, when I was a litigator, I really didn't like to lose.
No kidding.
Hated losing. So it's, as litigators, you have a unique opportunity, unlike almost any other profession, because you get to define success. You get to set the expectations for your client at the very beginning. So if I have one piece of advice for any lawyer out there who's litigating, it's you get the opportunity to set the expectations of your client. If they come in and it's a case that's viable and it can be brought, but it's going to be difficult, make sure you let them know that at the outset. If there's going to be collection problems, if there's going to be a lack of insurance available on the other side, a lack of coverage maybe, let the client know that up front, and then reinforce those expectations as you go. Because one of the biggest problems you run into in mediation is parties don't recognize the risk that they're about to take because the lawyer hasn't set their expectations correctly. And as litigators, we get to set that at the outset. If it's a tough case, I often have, people when I was litigating would come to me and say, well, I spoke to this attorney and he said this case is a slam dunk and would only cost $25,000 to litigate all the way through trial. And I say, okay, go hire him, because I don't think it's a slam dunk. Here's where I think your problems lie, and I'm going to need a $50,000 retainer.
Yeah.
And you have to tell them the bad with the good. You can't just sell the client because you want the fee and I don't think we have a lot of people in our community that do that. But you don't have to pump your client up. You give them genuine, rational, logical advice and let them make their decisions.
Well, when I was in law school about 12 years ago, alternative dispute resolution was starting to become more popular. There was collaborative type law in the family law sector. There was collaborative attorneys coming into probate. They sort of ADR was taking the mainstream. And then I saw things change a little bit where you see a lot of these things fail, but mediation is still required in some cases. And what do you see the expectations going into it? Do people feel like they're just checking the box and it's just one step before they can litigate?
Rarely. I think most people that hire me because they want to get the case settled. And
they've already failed at doing it themselves?
Or maybe they feel like the communication through a mediator is going to be more effective. You don't want to say to the opposing lawyer, hey, I recognize I have this problem
Yeah.
with my case.
But if
But you could tell a mediator and say, hey, mediator, I know that this is an issue. Here's the way I plan to deal with it, and I think I might be able to get over it. And then the mediator can take that information into the other room in a more neutral way. I think the communication is more effective through a mediator than direct, quite frankly.
So what makes a mediation successful in your eyes beyond just reaching a number?
Well, I find that, and again, it takes me back to when I was litigating. When I met with a client for the first time, my goal was to determine what was most important to that client. And that normally manifests itself in terms of time, money, or reputation. And when I say reputation, I mean the client's reputation to themselves as well as others.
Mm-hmm.
Can I resolve this case? Can I pay this person or accept this amount of money and still look myself in the mirror, feel like I did the right thing?
Right.
And so as a mediator, you kind of have that same issue. I spend a lot of time always talking to the parties, trying to figure out what's important to them. A lot of times it's not the number. Sometimes in a shareholder dispute, it's about an apology. It's about coming up with a procedure for liquidating a company. It's about how we're going to sell a piece of real estate, who we're going to hire, who's the realtor, who's going to be the closing agent, how are we going to do this?
Helping bring all the pieces together that need to come into place to resolve the matter.
Right.
With finality.
Right.
And avoid having to have a judge or extended, back and forth.
Well, and the other point that I don't want to be lost here, and probably the number one thing I do, right, is people come in and they want to talk about what happened to them. I hired a contractor. He didn't build the house right. There's mold. There was, I had plumbing leaks. The windows leaked.
Yeah.
The roof underlayment wasn't put on right. Whatever, construction defect cases. And they want to talk about all the hardship they went through. And you have to listen to that. You have to sympathize with that. But at the end of the day, you got to get the party to refocus on valuing their case, not valuing what happened. Because if they're valuing what happened, they're too focused on, quite frankly, what's fair, just, right. Well, you're going to go into court. You're going to go in front of a jury. This is the picture the opposing lawyer is going to paint. If the jury buys the picture that the opposing lawyer is painting, here's the likely outcome. Here, you have to evaluate what's going to happen in the future in court and make a decision given the remedies available in court. What can the court accomplish for you? The court can't, for instance, is not going to compensate you for all the time and aggravation in a construction defect case. There are compensable damages, and there are not. If you have an uncollectible defendant with insurance that will only cover certain things, they need to take that into consideration, because if they're going to go get a judgment that's not collectible or only a portion of it is covered by insurance and therefore collectible, they need to factor what their net is going to be at the end of the day. And some people will say, look, I don't care if it's collectible. I want the piece of paper so that I can show that I was wronged. And sometimes, again, that time, money, reputation, that's more important to them than the money. But opening their eyes to valuing the case instead of valuing the fact pattern is crucial.
Well, I think your insights into expectations and how your approach is really helpful for everybody who's listening today, because you often don't know what to expect in mediation until you're there at the table. So knowing how to prepare for it, knowing how to prepare your clients for it, I think that's huge, and probably makes the mediator's job easier if they've gone into that mediation having already done that work.
One of the questions you asked me to prepare for is what advice would you give to litigators and everything? And it's those two things: set expectations and prepare. My father used to tell me. My father was an attorney. He ran the law department for Florida Power and Light. That was the only client he ever had, right? From the time he got out of law school till the time he ran the law department.
Interesting.
And he used to tell me preparation for a trial lawyer or a litigator, preparation is never done. both attorneys are trying to get as far down the road in preparation as they can. And whichever lawyer is more prepared is usually the one that wins. And in my case, it's whichever lawyer is more prepared and has prepared their client more is more effective at mediation.
Well, so if you have two lawyers at mediation, one's prepared and one's not, does that often result in a stalemate at mediation?
It can be problematic if one side is not prepared on a particular issue.
Mm-hmm.
Maybe they haven't done the discovery that they should have done, or they haven't looked at the discovery enough to remember what was in it. And there are ways that a mediator can guide them to that.
Okay.
And there's a way that you can encourage the exchange of information to educate people that aren't as prepared, and still get to resolution.
What percentage of your mediations are mandated, and what percentage are voluntary?
Ooh. It's hard to say because you do a lot of pre-suit mediations that are either in contract or by statute.
Mm-hmm.
They have to do before they file suit.
Yeah.
And so I don't know if I would call those mandated. I guess I would call those mandated. So in that case, I'd probably say 70% mandated, 30% voluntary. Maybe a little higher voluntary. I know there's a lot of attorneys in town, and the attorneys we have in Collier County should be applauded for this. They file a suit and they say, hey, let's go to mediation right away. Let's see if we can get this settled.
As opposed to trying to settle it themselves, going through the normal discovery process and saying, all right, here's where we're at.
Well, and particularly today with the mandatory disclosures and everything, we both exchanged some initial information. Let's try to settle this before the attorney fees are running the case. We don't want the tail to wag the dog. And in doing things by Zoom, I have quite a few lawyers from the East Coast, from Jacksonville, from Tampa that hire me on a regular basis. I mean, still the majority of my cases are in Lee and Collier County, certainly, but I'd say 25% of my cases are from outside of those two counties. And like I say, lawyers learn of you, insurance adjusters learn of you, and they say, hey, I want this guy. We need this guy in this case, which I always tell lawyers, you can give me the easy ones too. You don't only have to give me the ones where your client's a problem, you're having a hard time controlling a client's expectations, so you need to bring Steve in. I can do the easy ones too.
Yeah, give me the ones where both lawyers are prepared and the issue is really easy to narrow.
Look, again, we keep going back to litigating. When I was litigating, I always wanted the second best lawyer in town on the other side. Every litigator wants the second best lawyer in town on the other side because, you're the best.
Yeah.
Right. So, because if the other side has a good lawyer, they're going to give their client rational advice, logical advice, good advice. And the client is then going to make rational, logical decisions, which are predictable. And it makes it easier to guide the case where you want it to go and get it to resolution. So
what skills?
Same thing for a mediator. When I have good attorneys on both sides, when I have prepared attorneys on both sides, settling cases is much easier.
What's the fastest you've resolved or you've settled a case in mediation? What's the shortest successful mediation you've had?
Oh, I had one recently that, including drafting, was like an hour and a half.
Wow. And what was the issue? Without giving too specific.
It was a contract dispute, and really the only remaining issue was the calculation of damages. It was a developer that there were some problems with the house, and they conceded, there were some problems. A sub of ours made a mistake, and we want to get this resolved. And it was just a matter of finding a number, and we found a number very, very quickly. The lawyers were prepared and had a draft ready. They had already exchanged drafts before the mediation.
A draft settlement.
Mm-hmm.
Well, that was leading good to my next question. What skills matter most for attorneys when they walk into a mediation?
Problem solving, just like anything for a lawyer. Litigators are really problem solvers, right? And sometimes the problem is the client doesn't know how to take advantage of this opportunity that's in front of them, right? And sometimes the problem is somebody's coming after them for a mistake they made or a problem. And, just trying to be as solution focused as opposed to quote unquote winning, looking for a way to get your client the most effective, most efficient solution. Here's one thing I often say to parties when they're talking about, well, I'm not going to settle. I want to take this to the mat. I have been doing this for 30 years. I have yet to have a client or a party come to me and say, you know what? I'm really glad I took that all the way to the mat, through trial, through appeal, through everything. That was a effective and efficient and enjoyable use of my time, and I'm glad I did it. Even the clients that have won.
Is that part of your opening statement?
No, but it is something I have used on occasion, but it still hasn't happened, and I don't think I've found another litigator that has had that happen.
So that's a pretty good indication that it rarely, if ever, happens.
Right.
Spending all this money and time, years in some cases, to reach the finish line, and both parties are never really truly satisfied that they went through that process.
Right. And by the way, I'm not just talking about plaintiffs. I'm talking about defendants too. I'm not going to pay. I'm not going to pay that much. I'm going to figure out a way to get out of this.
See, I think that's powerful because it's one thing if the attorneys are prepared. It's another thing if the client's expectations are in line with it and they're receptive to the advice they get from their attorney before they go into attempt and settle it.
Right.
Right. If they're too hard of a line drawn in the sand, then those are the ones that end up digging their own graves, so to speak.
Correct. It's always the most frustrating thing for mediators when you see people digging a hole and they just won't put down the shovel.
Well, how do you redirect clients in that, and how successful have you become over the years in redirecting them?
I think it's in directing them to what the court can accomplish for them and what remedies are just not available through the court.
So you see the opportunity to come up with remedies at mediation that wouldn't otherwise be available if you take it to the judge.
Absolutely, and that is one of the things you're required to tell litigants at the beginning of mediation is that it's a voluntary process. But that voluntary process means that you can do anything you voluntarily choose to do, which is very different than the options available to the court. So voluntary means flexible. Flexible means more options. More options is a good thing. So oftentimes you can find a solution that maybe involves the parties doing business together again on something else or finishing a project. Maybe they can exchange something other than direct compensation. That's something that the court would never be able to order anybody to do. Maybe a contractor, for instance, can undertake repairs, whereas the court's going to award money, right? In 95% of the cases.
I like that. So, as someone who doesn't have mediation as a regular part of their practice, it's nice to hear that because I often have the opportunity to talk someone off the ledge, whether it's a real estate transaction, they're disputing the deposit, or if they call me after a property closes and there was something they felt wasn't disclosed to them, then you can say, well, let's talk about this and have you tried talking about it. But one thing I'm seeing in contracts now, and this has existed for years, is you have an arbitration clause, but you don't necessarily have a mediation clause. So how would you distinguish? So mediation's always available, even if arbitration is the ultimate end in a case where, in a contract where they've agreed to that at the contract stage, they're not going to litigate. It's binding arbitration. How would you distinguish arbitration from mediation?
Well, arbitration, and I do arbitrations as well. Arbitration, the arbitrator is making a decision. In the case of a binding arbitration, he's making a binding decision that ultimately, if necessary, is incorporated into a judgment that can be enforced. Mediator, I have no power as a mediator to make anybody do anything. And interestingly, one of the things that we do a lot is we do an ARB med, and different mediators have different ways of doing this, but the way I do it is I do the arbitration first. I take a break, I jot down my decision, I put the decision in the drawer. I don't tell anybody what the decision is. I then come back and put on my mediator hat, and we mediate the case. Nothing I hear in mediation will change my arbitration decision. Arbitration decision is locked in stone.
Now, this is going into it as an arbitration hearing as opposed to a mediation, and then...
Correct. I like to start with arbitration, do the arbitration first, then put the decision in the drawer, go mediate the case, and I've probably done that 20 or so times in the last year and a half, 2 years, and once it did not settle. Only once did I have to pull that arbitration decision out of the drawer and incorporate it into an actual decision.
Interesting. I don't imagine...
Well, it tells you something about preparation because, and I always tell lawyers this, it's very important to give a solid opening in mediation. Let the other side, it's your one chance to talk to the opposing party directly. Give them your case. Tell them what your case is about. Be an open book. In arbitration, it's like a super mediation open, right? They literally hear everything. They hear how you're going to get it in. I'm going to call this witness who's going to say this. I'm going to enter this document through this witness, and this is how I'm going to do this. And at the end of the day, this is the picture I'm going to paint. Mm-hmm. The other side gets an opportunity to see that, and then they say, you know what? Maybe the arbitrator might buy that argument. I better think about compromising a little bit to avoid a harsh result.
I've sat in a couple arbitrations with the Board of Realtors, and I've seen that what you're talking about right now. I've seen it pan out. Now, you don't always have seasoned litigators in these arbitrations for fee disputes, so I think the preparation is key. But if you don't know how to prepare for that arbitration, so how do attorneys, especially newer ones, learn how to prepare for that arbitration? What things can they do? What resources can they seek?
Preparing for arbitration is similar to preparing for trial, but you're just telling the arbitrator what your trial plan is. Okay. Right? And the biggest thing I see in arbitration is lawyers come in and they just tell a story. Well, this is what happened. This person did this and that person did that. And that's not truly what you should be doing in arbitration. What you should be doing in arbitration is proffering your evidence. I'm going to call this witness. This witness is going to testify to these things. I'm going to admit these documents. I'm going to admit these documents through these people.
Okay, so that's required and customary in arbitration.
It's to proffer evidence.
Okay. Do you see that happening at mediation as well?
I think it's very effective in mediation.
So there's no rules as to how you to proffer, present, or open your statement in a mediation. Even though there's...
No. Many lawyers do PowerPoints. Many lawyers share the screen on Zoom, and they put certain documents up, and they show them, and they say, look, this document is going to come into evidence when we try this case. And what this document shows is X, Y, and Z. That can be very effective.
Transparency is one of the key words that I take about what you said. I think so many lawyers are trying to hide the ball. So mediation is the time where you lay it all out on the table before you're forced to.
I never thought hiding the ball was an effective strategy at any stage. I always thought the way I always litigated was, look, here are my cards.
Can't change the facts.
If you've got better cards than me, you win. Okay. But if I've got better cards than you, or if I've got a way of getting that card thrown out, which is going to change the way the hand falls, that's what we have to talk about. But I don't think, ambush tactics or hiding the ball or anything is effective at any stage of litigation, and certainly not at mediation. I've had people in mediation tell me, I don't want them to know this. I don't want them to know that. And I say, why? Why don't you want them to know that? If you tell them that, it shows that you have a very good position on this point or that point. Why would you not want them to know that? Well, because I don't want them to prepare for it. Well, it's going to come out eventually. We're going to get the case resolved. Let's go show them. Can I show them that document? Give me that document. Let me go in the other room and show them that document. And let's see what kind of effect seeing it on the screen has for them. That's very effective.
So sometimes the lawyer just needs to hear the mediator say that. It may be the first time that anyone's ever told that to him.
One of my standard lines in mediation is, if I'm asking you for permission to share something, it means that I think sharing it is going to help me resolve the case. And that's why I'm there. So bear that in mind if I make that request. If you say no, you don't want to share something, those are the rules. I have to follow the rules. But if I'm telling you I want to share something, it's not because it's going to blow the case up or strengthen the other side's position so that they want to continue to fight. It's because I think showing that piece of information is going to help the case resolve.
Yeah. Well, and so of course, mediation doesn't happen in a vacuum. It's part of the larger legal community here. So I want to ask you a question. How does blunt mediation support or complement the work that the attorneys are already doing here in this community?
Well, I think it helps the attorneys get a positive result as possible for their client. A lot of people say the best settlements are where both sides are equally as unhappy, and I think that's completely wrong. The best settlements are when both sides are equally happy, and that normally is the case. The defendant or the party paying is happy to have this burden off their shoulders. It's over. One of the things you get out of settling a case is certainty. We small practitioners who run our own practice and everything, we're business owners, right?
Mm-hmm.
The most valuable thing you can have as a business owner is certainty, right? So I think I help reinforce for the attorneys, who are telling their clients, look, these are the risks at trial. We can eliminate those risks and get a reasonable result in this way. And then when they hear it from another attorney, you hear another attorney saying, hey, I agree with what your attorney is saying here. Or if I put forth a risk or a circumstance, the attorney has an opportunity to say, yeah, you know what, he's right. And I help them guide their client to a positive result. So that's where it helps. And I often have attorneys call me and say, look, I'm calling you before this mediation because I want to let you know my client is very difficult. That certain pieces of advice I've given them they don't want to follow. I really need you to beat them up on this point or reinforce that point for me. And I'm a neutral third party. And there are times when I'll say to them, I don't agree with you. I don't know that I'm going to say that because I don't know that that's right. Let's talk that out before the mediation so that we're both on the same page. You want me on the same page with you before the mediation? Let's get there.
So it's a good practice to call the mediator to
give can be
background before. There's nothing against the rules or wrong with that.
Giving me a summary, very important. I'm going to look at the docket no matter what. I'm going to know who your judge is. And by the way, that can influence a case.
Who the judge is.
Who the judge is, absolutely.
Which seems
Are you going to get a continuance out of Judge Kyle? Are you going to get a continuance out of Judge Manuelich? And the practitioners know this. They know.
The best lawyers know their judges.
Absolutely.
And so the mediator can help bring that down.
And because I litigated here for 30 years, and because I'm talking to litigators even now that I'm not litigating, I know all the judges' reputations. And talking about who the judge is and what their likely decisions will be. Some judges are more technical than equity driven.
Okay.
Look, this is what the contract says. This is what I've cut a bad deal.
Yeah.
Other judges are, I'm going to find a way to cut this baby in half. And the best litigators all know who those are. And now procedure is a big deal because some judges are very harsh in not granting continuances and keeping cases on track no matter what. And by the way, we talked about every case going to mediation. Nowadays, almost every case goes to mediation twice because they'll go early on. The judge will say, we'll suggest it early on. Why don't you go to mediation early on in this one? This looks like one that might settle. And then if it doesn't settle at the first mediation, Then as they get closer to trial, the judge orders them back to mediation.
How frequently do the lawyers have draft settlement statements prepared before the mediation starts?
Fortunately, almost always.
Okay.
Very rarely do I not get any summaries. And that's important. And that's one of the things I did wrong as a litigator. I used to not send summaries to mediators.
All right,
and
so
that
you
was a
said
mistake.
summary, but what about a draft settlement statement? Settlement agreement, sorry.
Oh, how often? Usually because lawyers practice in certain areas, like they do a lot of construction defect work, or they do a lot of shareholder dispute work or real estate-related litigation.
Okay.
They'll have boilerplate stuff that they can modify pretty quickly, but the drafting process always takes longer than everybody expects. Always. So having one in advance can be, a lot of lawyers don't want to draft one and send it to the other side because they're afraid that they're signaling, we're going to settle this case no matter what.
Interesting.
So they hold that back. But I often tell litigators early on in a mediation, start drafting. But we're $2 million apart. Start drafting.
Okay. That's good advice, because that comes to the preparation side of it, where that's just one element of being prepared for mediation, is having that settlement agreement already envisioned.
Meet with your client. Try to reinforce the expectations that you've already set for them when you sign them up as a client. Make sure they're familiar with the Zoom process. Are they going to come to your office? Are they going to sit in the next office over on another PC? Or are they going to sit in the conference room with you? Are they going to join from somewhere else? If they join from somewhere else, are they going to be on solid Wi-Fi? Are they going to sign on from their phone from the job site and be distracted?
Yeah, I've seen that.
I've seen a guy sign on to Zoom while directing traffic of those giant dump trucks, the big yellow ones where the wheels are like 12 feet tall, right?
Yeah.
And they're zooming past him, going in different directions up at Babcock Ranch. And I just said, I'm not doing this. I'm stopping. Until he stops what he's doing and goes and sits down someplace where he can focus and not get killed, we're not going to go forward.
And even though you're getting paid to be there, you're also being hired to resolve this dispute and reach a settlement agreement. So if not everybody's taking it seriously, then you're doing them a disservice by allowing that to continue.
Exactly. And letting the parties know about the process, what's coming. We're going to have opening statements. During opening statements, pay attention to the other lawyer. I can tell you a lot of mediations, I spend the first hour calming everybody down, because during opening statements, one party or the other is shuffling papers and doing work on other things, and they're clearly not paying attention. And sometimes I'll even stop them. I'll say, hey, you know what? It looks like, defendant over there got a phone call or something. Let's pause and wait until he's with us again.
Yeah, and they might be thinking, well, as long as my attorney's paying attention, then I don't need to.
They're thinking, I need to show that this is nothing to me, so I'm going to put on a little show on Zoom. And it's better if the attorneys prepare them for that and say, look, if you know you have a client that might do that, and we all have clients that we know have a little bit of attitude one way or the other.
Or an ego.
You let them know, hey, pay attention to what they say. Let them know you're focused on the problem, because I don't want to have to deal with the emotion of the other side getting all mad that you didn't pay attention, because that's just going to waste our time. We're spending thousands of dollars an hour.
I think that's helpful hearing it from you, anyone who's listening or watching this, because you don't necessarily, like let's say you don't go to mediation all the time, or you're a new lawyer that's going to mediation for the first time, you're going to learn things the hard way unless you can be prompted in advance as to how to prepare. So, for instance, if I was asked to attend a mediation or represent someone in a mediation, because I don't do it every day, I wouldn't know where to start. I'd go on the internet and I'll search, how do you prepare for mediation, right? Or I'll call a mediator and say, hey, what do you think I can do here? But I don't know how much further I'd take it. Maybe that's why I don't have that.
It's funny you mention that, because just last week or the week before, I had a new young lawyer in town send me a mediation statement. And I read it, and as I'm reading it, I'm thinking, no human being wrote this. This is so obviously AI.
Mm-hmm.
I mean, the case sites were AI. The everything about it was clearly AI written. And so when I had an opportunity, I pulled him away from his client and I said, hey, by the way, I got your summary and it gave me the gist and everything. But I want you to know it was really obvious that it was completely AI written. And that's okay. If you want to write something, you want to send in something by AI, that's fine. But you should know that whoever's reading this knows you didn't write it. Because that might matter to a judge if you write something that way for them.
Mm-hmm.
It might matter to your client if you wrote something that way to your client. It is really obvious this was written by AI.
And what kind of a response did you get?
He said, yeah, you're right. He said, but, the circumstance, and I applaud him for this. The circumstance was his client was in a tough way financially, and he was trying to save money, convey the necessary information to me, but not have to bill his client for 2.5 hours for writing a complex mediation statement. So he punched in the facts and he got it out. And he acknowledged, yeah, that's not the way I would normally do it. But for this client who's on a budget, who's trying to focus their dollars on getting the case resolved, I thought that was the most effective way to do it. And that's an okay answer.
That's fair. And it seems like that lawyer would have been able to go a step further by telling that very thing to his client as well. And listen, I'm going to cut the time down it takes to prepare, and this is what I've prepared.
Right.
And then you have that client review it, and then they can fact check it before it's presented to the mediator or somebody else.
I think the document was accurate. It was just a lot of fluff that, was obviously not written by a human.
Yeah. Well, this conversation leads perfectly into your involvement with the Collier County Bar, because I know that's where you've gotten your reputation from, by getting out into the community and meeting with the other lawyers, getting to know them before you see them. So let's talk about that a little bit. How has your involvement with the Collier County Bar Association really influenced your work or relationships?
First of all, I can't imagine anybody not being a member of the Collier County Bar Association if you're an attorney here in town. I've been a member every year since I came here in 95. And, still remember going to the old Collier Athletic Club and so on. And so it gives you an opportunity to meet everybody. But it's interesting watching the way the CCBA has evolved. And this podcast is a perfect example of that. Because, we have a very collegial bar and everything, but that doesn't mean that we don't have to keep up with the times technologically and so on and so forth.
Mm-hmm.
So I've been a platinum sponsor now for, 7 or 8 years. I really became a platinum sponsor when I first opened Blount Mediation. And to be frank, it's because, now that's my target market is the lawyers. And it's interesting because a lot of lawyers, it's just a sidebar, a lot of lawyers that I always thought didn't like me when I was a litigator, that I would fight with tooth and nail.
Yeah.
And I think you know who you are. Now we get along like peas and carrots. It's fantastic. They call me about cases and say, hey, what do you think I should do with it? I mean, not even just as a mediator. They'll call me and ask me about how they can litigate a case, or what do they think about this case or that case. Or, how can I help them get this case or that case settled? And some of those people are like now my best customers. And I now realize they didn't dislike me. They just felt like they had to be adversarial with me because I was on the other side.
Mm-hmm.
And so now I have more lawyer friends now than I did when I was litigating. I'm happy to say.
Yeah, that's and for someone who doesn't litigate, I feel like I have more friends than the ones who do.
Right. Right. Because you can hang out with the litigator can hang out with the real estate lawyer.
Yeah.
Because
but when you get a room of litigators together, you got a lot of egos, right? I mean, all of us have an ego, whether we're a lawyer or not. But how have you seen the bar sort of bring lawyers together, and then ends up strengthening our community?
Well, again, I think things like this, because not everybody has the time. For instance, I would love to go to the trial lawyers luncheons. I would love to go to the CCBA luncheons. But when I'm in full day mediations on Zoom, it's just not possible.
Right.
A lot of times I'll buy the ticket and then I can't go because somebody books me that day. So things like this and the electronic version of the adverse witness and so on give me an opportunity to stay in touch with all those people and still feel part of the organization, even if I can't go to the events as much as I used to.
Mm-hmm.
Which, to be frank, now I miss. It's funny, when I was a litigator, I always dreaded it. You got to go to the CCB, got to go to this luncheon or that luncheon. And you're like, I got to go around and, so-and-so that I have this case against will be there, and so-and-so that I have this case against will be there. And
But you still did it.
But you still did it, and you always enjoyed it once you got there.
Mm-hmm.
But now I miss being able to go. I miss being able to go to the CCBA events. I miss when I don't get out in time to make it to the ends of court. All those things that our bar association is so good at. It just, the one thing about being a mediator that people forget is you are less in control of your own time. I go to work in the morning and I start a mediation at 9, and I don't know if I'm going to be done at 3, or am I going to be done at 7,
Mm-hmm.
or am I going to be done at 2:00 in the morning?
Which
Because
you
I'm not leaving. I mean, I'm going to go. If we're making progress, we're going to go. And I've had mediations that go until 4 or 5 o'clock in the morning. Not often. Not.
I couldn't imagine that even happening even once, other than maybe something I've seen on TV.
It does happen, and it happens more often in in-person mediations than by Zoom.
So you hear that, everybody? If you go into a mediation with a complex issue, be prepared to stick it out to the end, which may mean missing dinner and bedtime.
Right. I've had lawyers say to me, "Hey, is this going to settle or not? Because I want to go put my kids to bed." And the other side says, "Okay, we'll take it. Let's get done. And let's get the draft rolling."
Okay.
And the advantage of Zoom is that lawyer can start home during the drafting process. Can say, "Look, I live 20 minutes away. I'm going to sign off. I'm going to sign back on from my iPad when I get home." And we're going to,
yeah, that's a good point.
So the Zoom gives us all a lot of flexibility in our profession that I think we need to recognize and appreciate.
So now that you're a neutral, what does a healthy legal community look like as a neutral?
It looks like Collier County. I think we have a very healthy legal community. I think we have a lot of very good lawyers. One of the unique things in Naples is even small cases are big because of the property values in town and because of the...
When you say small, what makes a case small? A single issue, a single asset, a lower number?
Well, no issue is small to the litigants because they went to have people don't go to a lawyer because they have a legal problem. People go to a lawyer because they have a personal problem. Something in their life has created a problem for them or maybe an opportunity for them, but it's personal. It's not, even if it's business, it's still personal. A businessman or woman that's fighting with their partner, this affects their income. This affects how they're going to take care of their family. This affects how they feel at night when they go to bed, their stress levels. It's all personal, right? Well, in some communities, you just don't have the kind of money you have here. So even though it's personal, and a big deal to anybody, it's not unusual to have a multi-million-dollar construction defect case in Naples. I think in Dade County, per capita, it's probably a lot less.
Mm-hmm. Makes sense.
We also have the issue with the jurisdictional limits of the court, and you could do a whole podcast on that. But
maybe we will.
They waited about 30 years to move it from 15 to 50,000. They waited about 30 years too late to move it up, and it needs to be moved up again, in my opinion, because you cannot, in an economically efficient manner, litigate a $100,000 case in circuit court. And that's one of those things about setting expectations with your client. Sit down with your client and say, "Hey, you've got a problem. You've got a $90,000 case here. If it were a $50,000 case, we could file it in county court and be done in 8 months, maybe a year. Circuit court, we're not going to be done for 18 months. And maybe 24.
What's the average timeline that someone will see you in the evolution of a case? 6 months, 3 months?
Normally, most parties try to mediate pretty early on, so in the first few months of a case.
Mm-hmm.
And then the court always sends them back in the last few months of the case. So there are really two windows there. And in the first window, the attorney's fees are not driving the bus. And in the second window, attorney's fees are often driving. I have cases that will go to another mediator early on. They don't settle. They come to me later on, and they settle for very similar numbers to what was exchanged in the first mediation, but they weren't ready. Everybody goes through, and again, I could do a lot of time on this subject. Everybody goes through the same process in solving problems. First step is to identify the problem and then identify the solution to the problem. If they can't identify the problem or the solution to the problem, their frustration level grows. And as their frustration level grows, they direct their frustration at the problem itself, then at the perceived source of the problem. So at some point, the lawyers, they're all bad, right? That's why I have this problem. The court system is no good. That's why I have this problem. Because they can't find the solution they want. Well, at some point, that frustration level peaks and they disengage. And when that happens, they're ready to settle. And
so the closer
I've watched that go on with every case I ever had. There's a longer lesson about that I learned when I was in college at FIU. And it's the one thing that I truly remember from college was this particular lesson. But it takes way too long for here. But I watched that play out in every case I ever had, and in almost every case I mediate.
Well, for me and for many people listening, I imagine this is really helpful because there's a certain aspect of mediations that's secretive, right? It happens behind closed doors. You're not supposed to discuss it. And it's good to hear from someone that's got that inside view of hundreds of cases, having settled them successfully, that there's so much we can learn from you as a mediator by hearing these things. So I really value that.
Oh, I appreciate that.
Before we wrap up, we end every episode with a few signature questions. So one question I have for you is, what keeps you passionate about the work that you do?
Helping people. I love helping people. I love what I do. When I wake up in the morning and I have a mediation, that's a good day. When a case doesn't settle, I'm frustrated that I was unable to help those people solve their problem, get out of litigation, move on with their lives, and that they're left oftentimes in a very frustrating situation. To helping people, always.
And that includes not just the litigants, but the attorneys.
Right.
You're helping them get closer to a resolution. And you already answered one of these questions, what advice you give to attorneys that are earlier in their careers, and that is be prepared.
And set your client's expectations. Set your client's expectations. I had a former partner many, many years ago that would meet with clients and say, oh, yeah, Steve will go win this case. No problem. It won't cost nothing. And then I would meet with the client and explain all the problems with the case. And they'd say, well, but he said, I said, well, he's not a litigator. Sorry.
Yeah.
You have to set your client's expectations, because if you tell them you're going to win every case, it's not true.
Or if you misassess it, even though you're confident, you have to still know that you could be wrong.
There's maybe some fact you don't know about yet. You may get a judge who's having a bad day and makes a bad decision. The system is not perfect. And the other side is not going to agree to all these facts. You're going to say this happened, and they're going to say that happened. And if the jury believes that happened instead of this happened, we're going to have a problem. Your client needs to know that juries don't always get it right. I don't want to put politics in it, but I use this example all the time. Donald Trump will tell you he did not defraud Deutsche Bank. Deutsche Bank will tell you Donald Trump did not defraud us. But a jury decided that he did. So legally, it is a legal fact that he was convicted of fraud. think what you want about that on one side of the aisle or the other, but it's a perfect example of sometimes the jury's version of reality doesn't match anybody else's.
Interesting. Which is why you should always go to mediation voluntarily and try to settle it the first time around.
Get a solution that you can control, self-determination.
Yeah, that's good stuff. Well, one last question I have for you is, what does legacy mean to you, personally or professionally?
It's leaving a my dad used to tell me, always give your client a little bit more than they pay for, and always avoid even the appearance of impropriety. And if you can do those two things and help people, the legacy will take care of itself.
That's something similar to what Richard Treasure had to say, is you always, when you meet with somebody, you always give them more than what you think they came there for. You always go that extra mile, right? Sometimes that's harder to do when you're thinking, what value you're providing them, but the value that you have to provide is your experience. So you know what's going to add value. They don't necessarily know what's going to add value, and you just pour into them, doing one more maybe meeting before the mediation or going that.
Well, in mediation, and I learned this from Jim Nolman, if the case doesn't settle, it's not going to be because of me. I'm going to do everything I can to help you get the case settled. And if that means after the mediation, I'm going to field a few phone calls, or I'm going to go send a few more emails, or I'm going to get on the phone with the lawyers and I'm, follow up, or I'm even going to call lawyers. I keep track. I move my cases into a settled pile and a not settled pile. And periodically, and then there's some cases I leave in limbo, and I'll call those lawyers back 2 months later and say, hey, this case we mediated a couple months ago. Where are you guys at on that now? Can we get that case resolved? And a lot of times we resolve it during those discussions, and I don't bill for that. I don't charge for that. That's follow-up. I only bill if we reconvene for another mediation. Mm-hmm. But I don't think a lot of mediators do that. Jim's the only one that I know that does that on a regular basis. I think Bill Hazard does it as well. But that's part of that. Give my client a little bit more than they pay for. Follow up. And sometimes it's shocking what you find out. And then it's just interesting, because you hear what happened, that some dramatic thing happened. Maybe one of the parties that was so sure that they were going to do X, Y, and Z passed away.
Yeah.
And you know what? Now the case isn't important anymore. Or somebody got a new job, moved out of town, or circumstance changed, and suddenly everybody's ready to settle.
Well, I think many people want to know what's in it for them when they decide not to make a follow-up call like that. So you think if you do it just to do it, you'll be surprised how much you actually learn about yourself and about others, and you can apply that knowledge to the next case that you get, or the next case that you want to follow up on. And it just continues to build momentum where you become stronger because of it.
Right.
And you get better at what you do.
Yep.
Well, I want to thank you for all the support you do for all the attorneys in town and across the state. You play a really important role here, and I don't think enough people realize that. That you have a title, right? You have a practice name, but you don't really get to see the human side of these things unless you're on that Zoom call mediating an actual dispute. So I want to thank everybody who's listening as well, and tune into the Collier County Bar, all the other sponsors, the Platinum and Diamond sponsors. And so we'll end here. This is the Collier County Bar Association podcast, powered by Beyond the Briefcase. And I want to thank Steve again for coming on.
All right. Merry Christmas.
Thank you.